Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Welcome to Synergy's Third Thursday webinar. My name is Jason Lazarus, Chief Executive Officer of Synergy Settlement Services. Today I'm going to talk to you about mitigating Medicare secondary payer liability related to futures. I'm going to talk a little bit about lien resolution as well for conditional payments and Medicare Advantage liens. But the focus of this really is all about mitigating the risk for your law firm when dealing with Medicare beneficiaries. Before getting started about the specifics with Medicare, I wanted to first just talk a little bit high level about different government benefits, because oftentimes there's confusion by both the personal injury victim and sometimes the personal injury lawyer. People that are on needs-based income and asset-sensitive benefits are those that receive Medicaid and SSI, supplemental security income. Those are impacted by even a small amount of money received at settlement, as low as $2,000, because they're needs-based and income and asset sensitive. And liens can arise with Medicaid benefits, but Social Security does not ever assert a lien. So those are the needs-based benefits. The bottom part of the chart are the entitlements, which are Medicare and Social Security Disability, SSDI. So Medicare is what our focus is today, but the way most injury victims become Medicare eligible is by virtue of disability. They become eligible for SSDI, which in turn means that they become Medicare eligible prior to retirement age. So there's a connection between SSD and Medicare, like there is between SSI and Medicaid. For example, in most states, $1 of SSI automatically gets you Medicaid coverage. So understanding the landscape of these government benefits and the type of planning that's required is important. So Medicare, as you're aware, has a conditional payment obligation, and then there's also this question of Medicare futures, which is what I'm going to spend the next few moments talking about. Social Security has no lien. They're nothing to do with Social Security disability benefits because those are not needs-based. So moving into this concept of Medicare secondary payer compliance when we're dealing with futures and the Medicare set-aside question, it's good to understand as a starting point that Medicare's interpretation of the Medicare Secondary Payer Act is that there are two obligations. One that's from the date of the settlement backwards, which are conditional payments, and then one from the date of settlement forward, which are Medicare set-asides and Medicare futures question. Surrounding that is this Section 111 reporting, and that's mandatory insurer reporting. Every settlement with a Medicare beneficiary is reported to Medicare, and Medicare gets a lot of information as part of that reporting, including ICD codes. This has implications on both the conditional payment resolution side and a future denial of injury-related care by Medicare. So it's important to have that background and understanding before we start discussing these issues a little further. But the issue of Medicare compliance as it relates to futures is really important because if you have a catastrophically injured client, it is possible that Medicare could deny injury-related care in the future because of that Section 111 mandatory insurer reporting. That can trigger a denial of care. If that happens, and while it's very rare, if it does happen, there's a very lengthy appeals process within Medicare that has to be exhausted, 4 levels to be exact, before you ever get to a federal district court and start arguing that Medicare's denial of care was improper. That means a client could go without care for over a year if Medicare denied care, and that would be really problematic in a catastrophic significant injury case. So because mandatory insurer reporting can trigger all of this, it's really important to consider what to do and how to protect your Medicare beneficiary client. The mandatory insurer reporting has many, many impacts. As I said, conditional payment, and also beyond that with Medicare futures and a possible denial of care. It's really important to understand what the defendant is going to report when that case is settled, what the ICD codes are, what the date of incident is. If they report the wrong date of incident, it can trigger a conditional payment demand that you didn't expect. Documenting mandatory insurer reporting is important for the plaintiff to understand what exactly is being reported, and that becomes really important when you have multiple injuries from a particular accident. Say you've got a car accident where there's neck and back injuries. Throughout litigation, the defendant takes the position that the neck was a pre-existing condition, and they ultimately settle and pay money only for the back injury. When they report, if they report the neck and the back, that's when you could have a situation where there's a denial of care for injuries that they did not pay a dollar for. So again, a lot of little issues surrounding this, and important to have an understanding of that background. So that brings me to what is a very important and timely discussion, which is what is the landscape as it relates to Medicare set-asides and Medicare futures. And very recently, there was an update by the OMB about the possible regulation of Medicare futures. So the agency, CMS, has had on its agenda for quite some time issuing proposed regulations. Very recently, that was updated, and what you see on the screen is a snapshot of the OMB's website, and it talks about what this rule would do, which is to clarify that an individual or Medicare beneficiary must satisfy Medicare's interests with respect to future medical items and services related to settlements, judgments, awards, or other payments. And these proposed regulations are supposed to come out at some point next month in August of 2020. We have no idea what they will say, what they will do, other than we know that they will address Medicare's interests with respect to future medical items. What that means is a mystery. We have some ideas as it relates to past statements and past conduct by Medicare, but the prevailing thought is that this will codify Medicare set-asides in liability settlements and give a framework for dealing with Medicare futures when you settle a case for Medicare beneficiary. But it's pretty key to remember some things about this whole area as we sit here today. Right now, there's no regulations, there's no statutes requiring an MSA. So really, it's very similar to special needs trusts, where you have to explain to a client who's on Medicaid and SSI that there is a vehicle called a special needs trust which can protect your eligibility. With Medicare, it's really no different. It's explaining about MSAs, explaining about the risks, because without that, the client can't make informed decisions. So a key thing about this, though, is that you only have to worry about this when you're representing a client who's a current Medicare beneficiary, which means they're either disabled, 65 or older, have end-stage renal disease, uh, are suffering from ALS, or are a disabled adult child. There is an argument that also you want to be considering these issues if you are representing someone who has a reasonable expectation of becoming a Medicare beneficiary within 30 months. That is because they have applied for SSDI and are currently receiving it. So within 24 months, they will become a Medicare beneficiary if they fall within that category. Although that reasonable expectation category is really an extension of what's done in workers' comp, and there is no corollary in liability settlements. But one of the really key takeaways from all of this is that really what I'm suggesting is not that an MSA is done for every Medicare beneficiary, because there certainly are alternatives to doing an MSA. Really what you have to make sure is that you don't have a settlement that shifts the burden from a liable third party who's paying dollars for future medical to Medicare. There's ways to do that without setting up a Medicare set-aside. For example, the client could enroll in a Medicare Advantage plan, they could get private insurance, they could self-pay, they could do a medical management trust for future medical, they could do a structured settlement. There are different ways of making sure that there's no issues with Medicare compliance, but those have to be evaluated and investigated. But if you have someone that's Medicare eligible, is going to require future treatment, and is getting dollars to fund future medical, that's when you want to look at considering an MSA analysis or some type of alternative. Medicare's position is that an MSA is their preferred method to protect the Medicare trust fund. And if you don't take anything else away from today's presentation, one of the key things to remember is that you really need a process within your law firm to identify cases involving Medicare beneficiaries. And then once you identify, then you need to ask certain questions. Does that settlement fund future medicals? If the settlement does, then figuring out how to educate the client about the risks of failing to do anything as it relates to Medicare futures, and then ultimately select an appropriate solution that fits within the risk tolerance of your client. And an easy acronym to remember it all is CAD. You want to consult appropriate MSP experts, you yourself, or have experts advise your client about the MSP and its implications in that case. And then probably most importantly, documenting your file as to what you're doing and why you're doing it, the legal basis for doing it. Because today what's happening, oftentimes we see, is that the defendants are putting onerous release language into the release, pages and pages about Medicare compliance, shifting the burden to the plaintiff, telling them that they can't apply for Medicare or Social Security disability even, really things that jeopardize your law practice in terms of malpractice liability, because if you have settlements involving Medicare beneficiaries that are being treated differently just because the defense is including certain language or including token amounts for MSAs, you probably have a liability issue within your firm because your clients are being treated differently. They're not being educated about these issues. So having a systematic process to do all of that is incredibly important going forward. So if you do represent a client who is Medicare eligible and is treating, then you need a Medicare expert case evaluation when you settle that case. This is a service that Synergy has developed, and really all MSCC is it's giving you resources, giving you an expert as it relates to Medicare futures that you can rely upon to help you consult about the issues that you may be facing with a release, questions that the client may have. So consulting with the client, giving you templated communications for the client to educate different types of forms to document your file depending on what the client decides to do, helping you document your file to close it compliantly. Doing all of those things are really, really critical for meeting your obligations as it relates to Medicare futures. And the cost is relatively low. $1,000 includes all the consultations, all the templated communications, acknowledgments that the client will sign, all those services that I described. You know, at the end of the day, you know, the whole system as it operates is flawed because you're taking all the risks and representing the client. And then at the end of the settlement, the defendant is dumping this Medicare compliance obligation on your shoulders. And really that's where our services are incredibly valuable for you to make sure that you've got a comprehensive plan so that the file is closed compliantly and the client is given the proper information to make an educated decision about what to do. So the idea of our services ultimately really are all about protecting your law firm and your client together simultaneously. So doing that Medicare expert case evaluation, determining whether the client does want to do an actual Medicare set-aside, which if they do, that's part of what we can do is provide the allocation services, also developing funding solutions for that MSA using structured settlements, and ultimately providing professional administration of the MSA should they decide to implement one. So real quickly, I did want to touch on this idea of protecting the client if they do an MSA from making mistakes in administering these things, because MSAs are complex animals. And if a client is dual eligible, meaning they're Medicare and Medicaid eligible, or Medicare eligible and they're setting up an MSA, if proper planning is not done and a professionally administered MSA is not done, they can jeopardize their benefits. So one of our solutions is a pooled Medicare set-aside trust, which can be used for both clients that are dual eligible, which is an MSA SNT, or just purely an MSA that's professionally administered. So the way most of these MSAs are administered are through custodial arrangements with companies that provide that service. The downside to that is that those companies can go out of business, and there's not a plan for it to go on in perpetuity when an MSA could last 20, 30, 40, 50 years. A trust arrangement will go on in perpetuity because if the trustee can no longer serve or the MSA administrator can't serve, those entities can be replaced by the terms of the trust agreement. So it basically allows the client to have all the benefits of having that guidance and professional administration without having to worry about in the future if that arrangement will persist long years down the road. So since I said at the outset I was going to talk a little bit about Medicare conditional payments and Medicare Advantage liens, I'm going to move towards addressing that. So we just spent some time talking about sort of a little bit in reverse order, talking about from the date of the settlement forward. Now we're going to talk data settlement backward, which is conditional payments. Now, this area has become problematic for personal injury firms in terms of liability for the government looking at examining what they're doing and going after firms that are simply not complying with the Medicare Secondary Payer Act. And this particular instance was of interest to me because it was such a small amount of money, yet the Department of Justice pursued a Philadelphia-based personal injury firm for recovery of that small amount. But as part of their resolution of this DOJ action, the firm agreed to name a person responsible for paying Medicare secondary payer debts and train their employees to make sure that Medicare conditional payments are reimbursed timely. What this shows you is the seriousness of the government's um, position about making sure that Medicare is reimbursed. And at the bottom of the slide, the quotation about lawyers needing to set a good example and follow the rules as it relates to Medicare reimbursement, and talking about how the government will aggressively move to recover the money on behalf of taxpayers, and they will do it by going after law firms and going after lawyers individually and personally. Similarly, this other instance, which there's been multiple of these, but this one in particular was a case where the government was going after a law firm who had referred matters to another law firm, which is interesting in that it is suggesting and going after the law firm who referred it, saying, even after you refer it, you still have an obligation to make sure that Medicare is properly reimbursed. So when you're referring cases to another firm, not only do you have to make sure you've got a written fee agreement and you've got copies of the lawyer's malpractice insurance policy declarations, but you basically want to know that that lawyer is resolving the Medicare conditional payments or coming to a company like Synergy to make sure that those obligations are addressed and properly resolved. I wanted to go through briefly this scenario, which is a real-world example of exactly what happened, which led to ultimately the government pursuing a law firm. This particular firm was handling a medical malpractice action, put Medicare on notice of the action. The law firm received a conditional payment letter of $14,990. The law firm relied upon that figure to settle the case. The case ultimately was settled and Medicare was put on notice of the settlement. And 60 days thereafter, Medicare issued their final demand, which was $330,000. Obviously, big problem. The mistake that was made here was that a conditional payment letter is non-binding on Medicare. That's just an interim amount. The final demand, which is triggered when you give Medicare your settlement details and amount, is what actually can be relied upon. Anything that Medicare says or does before that, they're not bound. So in this case, the law firm pursued an administrative appeal to appeal the amount, the $330,000 amount, because they settled it based on thinking or allegedly thinking it was $14,990. Ultimately, the appeal was denied. The matter was referred over to Treasury, and the U.S. Attorney's Office sent a letter demanding payment. And ultimately, the law firm wound up turning it over to their E&O, who paid a reduced amount. You don't want to be in that situation ever. So you really have to make sure that you have processes in place to prevent something like this happening. So the way to do that is by understanding the process and making sure your team understands the process, and or outsourcing it to a firm like ours. But the first step is reporting the case to Bcrc. The Bcrc will issue a rights and responsibilities letter. Then the Bcrc will identify Medicare's interim recovery amount. That's that CPL. You can't rely upon that. What you want to do is review that, dispute any unrelated charge, so you're auditing and verifying. Once the case settles, at that point, you're going to get a final demand. That number could be very different from the CPL. If the final demand is not paid, then interest is going to start to accrue. And then ultimately, if it's not paid, it gets referred over to Treasury for collection after 90 days. So let's talk a little bit about the resolutions. I talked about the process before and the importance of having a process within your law firm. One thing to be very cognizant of is the right way to resolve Medicare conditional payments. And this particular case, this United States v. Kerrigan, is an example of how not to do it. In this particular instance, the government brought action uh, on behalf of CMS to recover payments made by the Medicare program because of the way this was handled. So in this particular case, what happened was um, the lawyers did not agree with Medicare's final demand, and they went to a state court to get a determination of the lien amount, and the state court reduced the Medicare conditional payment amount. But the problem is the state court had no jurisdiction to do so. So the government filed an action in federal court against the trial lawyer saying what you did was inappropriate, and they're ultimately going to prevail because that is not the proper channel. You cannot go to state court and ask the state court to rule on federal laws and bind the Medicare agency. They are always going to fight that. So there are different ways to resolve Medicare conditional payments without going down the path of trying to involve a state court on a federal law issue. There's a right way to do this, and the right way is to take a look at the different Medicare conditional payment resolution options and decide which way makes the most sense for that particular instance. A lot of times, paying the amount after audit and verification of the Medicare conditional payment final demand makes sense. Now, if you don't do that, another option is just simply to appeal the amount. Those different levels of internal appeal that I mentioned, the 4 levels and the lengthy timeframes all apply, and you have to exhaust those before going to a federal district court. If you appeal but don't pay the final demand, interest continues to accrue and pile on all during the pendency of those appeals. So it's not a very attractive option. So really the best options are either pay the amount and take up an appeal, or pay the amount and seek a compromise or waiver. So if you're successful, then with a final demand, compromise, or waiver request, you get a refund back from Medicare. They actually issue a check back. There's 3 different provisions under the law that allow you to seek a compromise or waiver. There's a hardship. There's a basically looking at the chances of success in litigation, which is that FCCA, and then the best interest of the program waiver. And there's different criteria for these. Hardship is really financial hardship. FCCA is really equitable principles, and the best interest is sort of a catch-all. But you can make a request simultaneously under all these provisions if they applied. And that's sometimes what's done, or it may be a situation that lends itself more to a hardship waiver. But if you're successful with any of these requests, then basically Medicare will issue a refund. And as an example, this is an actual case. This was a negligent security case with a 7-figure recovery, so a substantial recovery, but there was financial hardship. The Medicare beneficiary was also eligible for Medicaid and was not in a great financial situation in spite of a large recovery. The conditional payment amount was $159,000. This woman had been shot multiple times by an assailant and was significantly injured. Her daughter, who was throwing a birthday party for her granddaughter, was actually killed. It was a very tragic case. So we were asked to resolve the Medicare conditional payment. We were able to get that Medicare conditional payment completely waived, even though there was a 7-figure recovery based on that financial hardship argument. So it is very possible to get that refund. And this slide gives you a couple of stats about what we do in our success rate. So our Medicare compromise and waiver service is successful 77% of the time. And last year we recovered in excess of $1.2 million on behalf of Medicare beneficiaries. And the average amount refunded was a little in excess of $16,000. Since we began offering this service to trial attorneys and their clients, we've recovered in excess of $6.8 million. It's very possible to get these Medicare conditional payments either compromised or waived. You just have to know the right way to do it. And if you don't know how to accomplish that, then you should outsource it to a company like Synergy. So moving along to Medicare conditional, from Medicare conditional payments to Medicare Advantage liens. And I call these hidden liens because when you contact Medicare and request a conditional payment amount, if someone has gone from Medicare Part A and Part B, which is traditional Medicare, to being covered by a Medicare Advantage plan or Part C, CMS, when you ask about the conditional payment amount, will not tell you if there's a Medicare Advantage lien. And the reason they won't is because they don't know. They don't have that information. So it can be one of those things where you just don't know that there is a Medicare Advantage lien out there because of the fact that it is not something that you will know about unless you do an investigation and figure it out for yourself. So Medicare Advantage plans are simply plans that are administered by private insurance companies that are subsidized through Medicare. And these Advantage plans have the same recovery rights as Medicare itself, but typically they are more willing to work and reduce liens based on the arguments of equity and fairness like you would have with other lien holders. But what the MSP has and these Medicare Advantage plans have realized is that there is a provision for a private cause of action for double damages when a primary plan fails to reimburse the Medicare Advantage plan for payments it's made. And because the Code of Federal Regulations extends that private cause of action to the Medicare Advantage plans, and because Medicare has taken that position, and because there's case law out there that supports that, at least in some of the circuits, you have to be very careful of that, because if the Medicare Advantage plan decides to be aggressive, they can seek double the amount of the lien if that lien is not satisfied out of the settlement. And one of the problems under the Medicare Secondary Payer Act is that lawyers personally can be held accountable for those double damages because of the way the statute and the regulations are written. And there are instances where the government has tried to personally hold attorneys liable for Medicare conditional payments, and there is a growing body of litigation where law firms are being sued by Medicare Advantage plans for double the amount of the lien. One example is the Humana versus Paris Blank case, which involved a law firm we worked with, and they were sued by the Medicare Advantage plan for double the amount of the lien, and that ultimately had to be resolved confidentially during the litigation, but they wound up having to pay. So the bottom line of the Medicare Advantage plans are that you have to delve into the client's background in terms of where they've treated. And one of the clue-ins here is that if you contact Medicare and ask for a conditional payment amount, and they say there's zero, and you know that there's been substantial treatment, it's probably highly likely that Medicare, the A and B coverage, was switched over to Part C at some point, and that's who provided the bulk of the care. And so one of the ways to do some of this investigatory work is to make sure you've got copies of your client's insurance cards and Medicare cards, and look at the situation as a whole to figure out if possibly there is potentially an MAO lien involved. And you really need to make sure that your staff understands these issues and is looking at these issues and training them to make sure you find these MAO liens because of that personal liability. Our lien resolution group has almost a 60% reduction rate on Medicare Advantage liens. So these are liens that can be negotiated and resolved. But the important part is figuring out that they exist and making sure that they are proactively dealt with. So hopefully that gave you a little more insight into mitigating Medicare Secondary Payer compliance. I wanted to end, that's a shot of our team from our most recent annual meeting. And what I'm really proud of is that our team is really, truly dedicated to helping injury victims and is focused and incentivized on getting the best possible results and protecting clients, because that is at our core, is helping improve the lives of those we serve. And it's a passion of mine. It's important to me that we always remember and focus on the people that we serve, because they've typically been through something quite catastrophic if they are needing our services. So that's a team that really truly believes and buys into that mission, which I'm very proud of. If you have any questions about today's presentation, that's my email address and phone number. Happy to answer questions. If you want to do a deeper dive on these subjects, I can send some more detailed information to you, and happy to provide that upon request. Just briefly before we end today's presentation, I just wanted to talk quickly about what we do. Basically, we help trial lawyers focus on what they do best and deal with the issues that they face when they resolve a personal injury case, from dealing with liens, dealing with the Medicare Secondary Payer compliance issue, settlement consulting and government benefit preservation, structured settlements, trusts, and ultimately tax deferral of contingent legal fees. If you want to learn more, you can visit our website at synergysettlements.com or contact us toll free.
There were a few questions at the conclusion of the presentation that I wanted to address. One of the questions was, can Synergy help do an audit of Medicare files to identify which ones are best suited for Medicare compliance services? That absolutely is something that we can help with, along with helping to create processes for MSP compliance within your law firms. As I said during the presentation, that those issues are vitally important to be addressed in your law firm. And in addition, we can do MSP compliance training for your firm. So those are services that we offer to our clients, and happy to provide that to you to assist with these sorts of issues. Another question was whether I believe that we'll see Medicare set aside actual regulations before the end of the year. I'm really not sure. We're expecting proposed regulations sometime in August from Medicare, but the process could drag out. Not sure if they're going to solicit public opinion like they've done in the past, or input from providers and people that are part of the system. So it really is a guesstimate as to whether or not that's going to be possible or not, but we should know a little bit more next month when we get these proposed regulations. Another question was, how do you make sure that you don't have a final demand that increases after you get conditional payment notifications that are lower? And there really is no good answer to that, except that if if you are aware that there is care that has not been included in the Medicare conditional payment summary, you can probably safely assume at some point it will be picked up, assuming the provider has billed Medicare timely. So, ultimately, you as I said during the presentation, you just cannot rely upon the conditional payment letters because they're not binding on Medicare. Only the final demand is going to be binding on Medicare. A couple questions just about what we do in terms of our services. One question is, what is the settlement dollar threshold before needing to consider doing a Medicare expert case evaluation? There really is not a specific dollar figure. Really what you want to analyze is risk. So if it's a larger settlement with a lot of future medicals, then the risk of a denial becomes much greater for the injury victim. If it's a smaller settlement with relatively small future medical care needed, then perhaps you don't need to go down that route. But again, as I said, you really need to make sure that you have a process that is in place that you can show why you were doing and based on what principle. So, and one of the concerns I have for law firms out there is that there's a lot of cases that are being resolved today for Medicare beneficiaries where there's pages and pages of Medicare release language, and those releases could be very different in terms of what they say and the obligations imposed. And if you start looking at all the Medicare beneficiaries in your practice, you could have a quite inconsistent application of what you're doing for Medicare beneficiaries based upon what the defendants are imposing in their releases. So it just winds up being exposure really at the end of the day for a potential malpractice claim or the government pursuing action under through the DOJ. One question was about Medicare Advantage plans and Medicare's future interests. Right now, there really is nothing that a Medicare Advantage plan could seize upon to say that a Medicare Advantage plan beneficiary should set aside money, because Medicare set-asides are a creature of CMS's creation. They're not a regulatory or a statutory obligation, so there's nothing that extends MSAs to Medicare Advantage plans like you have in the conditional payment world. There are regulations, which I talked about in the presentation, that extend the Medicare Advantage plan's recovery rights or extend Medicare's recovery rights to Medicare Advantage plans. There's no corollary for Medicare set-asides with Medicare Advantage plans. So in my opinion, there is no obligation to set aside anything with an Advantage plan. And I've never seen a scenario where a Medicare Advantage plan has said that they are that they're entitled to the benefit of this policy regarding Medicare set-asides. Another question came up in terms of the Medicare waiver and compromise and whether there is any type of statute of limitations or time period within which you have to make a claim for a waiver or compromise. And there isn't any. You could go back years and attempt to get money back from Medicare. And in fact, our lien resolution group has done that for clients years and years after the Medicare conditional payment was paid. So it is an opportunity to go back and recover money from Medicare if those waiver and compromise processes apply to that specific case. And there really is no minimum final demand amount in terms of pursuing this waiver and compromise. Last question I got was related to the Medicare Portal and MAO liens. There is no portal for MAO liens, and MAO liens, Medicare Advantage liens, are not included on Medicare's portal because Medicare is not aware of those charges. That's why I was talking about them being hidden liens and the fact that you could have a scenario where the final demand is zero, and that's because a Medicare Advantage plan has paid, and Medicare will not be those charges. So really the best way to figure out if your client has a Medicare Advantage plan is to just become a detective and do some due diligence work. The scenario that I described where you know there's been quite a bit of medical, if the Medicare file demand is very small or zero, and your client's a Medicare beneficiary, then it's very likely that they've elected to become part of the Medicare Advantage plan, in which case you got to get your client's Medicare Advantage insurance card to know who that provider is. Could be Blue Cross Blue Shield, could be United Health. There's a ton of these private insurers that provide these Medicare Advantage plans. So you do have to do that due diligence work, and it's really important because these MAOs have gotten very aggressive on their subrogation efforts. It's very possible that you could be facing a lawsuit for double the amount of the lien if you fail to identify it and pay back that Advantage plan. And I think that is it. Let me just check real quick to make sure that there are no other questions. Yep, that is it. So want to again thank everybody for joining today, and we'll see you on the next third Thursday webinar.